Hi, I'm Brian Larson. I've prepared this presentation for students in Writing Studies 3562, Technical and Professional Writing. My goal is to give you an overview of the topics of law frequently referred to as intellectual property. This is part 2 of a 3-part video series. You should view part 1 before viewing this one. This video is for educational use only. Please contact me for permission if you wish to use it. This second video will cover the rest of the topic of copyright, and the third video will cover trademarks. Remember, before viewing this presentation, you should have downloaded and read Circular 1 from the United States Copyright Office. And I mentioned earlier that I'm a lawyer, and that also means that I just have to make a couple of disclaimers. I'm calling them your Miranda warning. These presentations do favor speed over thoroughness, so this is an extremely simplified view of these topics of the law, and I'm definitely skipping over some things that are very important for actually figuring out whether something is legal or not. Second, I don't mean anything in this video to be legal advice, so if you have a real legal issue in your school or work life, you should seek professional guidance. In part 1, we identified the types of intellectual property, we looked at the sources of law for copyright, and we considered what works are protected by copyright. In this video, we'll consider who the authors of copyright works are, what their rights are, how they protect them, what infringement is, and what the doctrine of fair use is. So first of all, the Copyright Act gives the author the exclusive right to do several things. And you'll find reference to this in Copyright Circular 1 on page 1. The author of the copyright work is the only person who can do those things with her work. No one else can do them without the author's permission. And that permission is referred to as a license. So let's take a look at the things that only the author can do with the copyright protected work. First, only the author can make copies of the work, and this includes photocopies, digital copies, or copies in other media. Second, only the author can create derivative works. These are works that are based upon one or more pre-existing works, and they include any form in which a work may be recast, transformed, or adapted. And that includes things like translating a book into another language or adapting a book to be a movie. Then we have the author's exclusive right for distribution. Only the author can distribute copies of the work. We also have the author's exclusive right of performance, and that includes digital or public performances. So you can buy a song on iTunes for your own use, but generally you cannot play it over the sound system at your business without the author's permission. That would constitute a public performance. You also have the exclusive right of display. Only the author can display her work. So even though you might buy a painting to hang it in your home for your own enjoyment, that doesn't mean you can display it publicly in a museum without the author's permission. You own the copy of the painting that you have, but you haven't extinguished the author's right to exclusively control its display. So let's consider who the author is of the copyrighted work. And here you might want to refer to Circular 1, page 2. Generally, the author of a work is the human being who created it. But if you create a work in the scope of your employment, the rule is different. Generally, if you write something for your employer owns the copyright, and you need your employer's permission to use it. If you're an independent contractor, generally you own your own works, but your contract may provide for an assignment or license to whoever hired you. This issue is important if you do technical communication work later on. So if you're wondering about whether the work you do whether you will own it or whether the person who's hired you will own it, you really need to talk to an attorney. Let's talk about the duration of the author's rights. So the monopoly that an author has on those exclusive rights we mentioned before is limited in duration under the Constitution, but the Congress has increased it a couple times over the last 40 years. So for a human author, the duration is the author's life plus 70 years. This allows the author to leave her copyright in a will, and her heirs will then enjoy the benefit for 70 years after her death. If the work is a work made for hire, the copyright lasts until 95 years after the publication or 120 years after the creation of the work, whichever is shorter. Authors protect their copyrights in a variety of ways. One of them is to register the copyright with the U.S. Copyright Office, and you can find information about that in Circular 1 on page 7. Copyright registration is not required unless you need to sue. You have to have a copyright certificate to begin a lawsuit, and you also need to register if you want statutory damages or attorney's fees. This is a big deal. The lawyer fees for a copyright suit are usually tens of thousands of dollars. If you cannot get the defendant to pay them, sometimes the cost of the suit will outweigh the damages. You can register most works online. The base fee is $35, though there are different fees for different kinds of works. And it can also be done at any time during the life of the copyright. Another step that owners sometimes take to protect their copyrights is a copyright notice. You can find more about this in Copyright Circular 1, page 4. This too is not required for protection, but it provides benefits. For example, putting the notice on your work shows that someone claims the copyright and that it has practical value. It shows who owns the work. Hopefully, if someone wants to use your work, they'll contact you. It helps if they know who you are. It also prevents someone using your work from using the innocent infringer defense. That is, someone who claims they used a work without knowledge that it was subject to copyright. If your copyright notice is on your work, it's very hard for someone to make that claim. The structure for the notice is very simple. You put the copyright symbol, the year the work is completed, and the author's name. If you can't make the copyright symbol, spell out the word copyright instead. Even though that's an English word, it satisfies the laws of all nations to use the word copyright. So let's talk about copyright infringement. As I mentioned before, the owner of a copyright, or the author of the copyright, has exclusive rights, things that only she can do unless she gives permission to someone else to do them. And that permission is called a license. So if you use a copyright owner's rights without a license, then you have committed copyright infringement. However, there are defenses against copyright infringement claims. In other words, if you've used a work without the author's permission, you may claim a variety of things. For instance, you might say the copyright is invalid. Maybe the plaintiff is not the owner of the work, or the work is not subject to copyright. You might say that you had permission. Permission can be expressed, like a written contract, for example, or implied. The third option or defense that you can make against copyright infringement is fair use. And fair use is very complicated. We could spend an hour talking about that just by itself. Actually, we could spend many hours. But we just need to give you an overview here so you have a basic understanding of it. Let's try a little bit of it. Well, I should say the fair use doctrine is a legal defense against the claim of infringement. So the defendant argues that despite the fact that the plaintiff may prove copying without a license or infringement, the defendant's use is still fair use. And there are 4 factors that the courts always consider when they're doing a fair use analysis. Those are the nature and purpose of the use by the defendant, the nature of the work itself, the amount and substantiality of the use, and the effect of the use. I'll talk about each of those individually. All these parts are considered together, and courts may use other factors as well. Notice that I did not mention giving credit as a factor, and we'll talk more about that in a moment. Let's take the factors one by one. The nature and the purpose of the use. So generally the copyright law is going to permit or encourage uses of copyrighted works under the fair use doctrine if they consist of criticism, so you are commenting or evaluating on a work. If it's news reporting, so if you provide a small excerpt of a work in order to report about it in the news. If you're doing commentary of some kind on the work. If you're involved in education, so you might copy a small portion of a work in order to use it in a class environment, let's say. Or if you're involved in research, and that's kind of the same sort of thing as teaching. Where the nature of the work is concerned, the court's going to be concerned with how long the work is, and how much work went into its creation, and also how readily available it is. If the work is not yet published, then it might be less likely to be regarded as fair use. The author has the right to try to control how much her work is being used, or by whom her work is being used. Then you also have the question of the amount and the substantiality of use. So, for example, if I take an excerpt out of a work, how far does the excerpt that I've taken go to the heart of the material that I've used or that I've borrowed from? And how much of the whole work is used? For example, if I copy a paragraph out of a 1,000-page book, that's more likely to be fair use than if I copy a whole haiku, which is a poem that's only 17 syllables long. And finally, the effect of the use. That considers factors like whether the use was commercial or non-commercial, if you use it for education versus using it for promoting your business. And it also considers whether the use that you make of the work actually deters or detracts from the benefits, future benefits that the owner is likely to get from the work. The more that you harm the owner's interest by copying the use or copying the work, the less likely it is to be regarded as fair use. So here's a reminder, all four of those factors are considered together, and the court may use other factors as well. And notice that I did not mention giving credit as one of the factors. So just because you copy something from someone and you keep their copyright notice on it, or you give credit that you copied from them, that does not protect you from a claim that you've made an infringing copy, and it does not automatically mean that what you've engaged in is fair use. So let's look at an example of the application of fair use. The Supreme Court decided an important case in 1985 called Harper and Row versus Nation Enterprises. That case involved memoirs that were written by ex-President Gerald Ford. And Harper and Row, who was the publisher of the book, who had the right to publish it because they had a license from President Ford, licensed key excerpts of the book to Time magazine. That excerpt included the pardon of President Nixon, and that's one of the most significant events that occurred in Mr. Ford's lifetime and in his book. The magazine The Nation got a hold of a copy of the excerpts that Time was going to print, and it scooped Time. It published them before Time did. So the question is, in the case of Harper and Row versus Nation Enterprises, what do you think? Was it fair use? In a moment, I'm going to ask you to stop the video and work through your own analysis of the Harper and Row case, but I'd like you to consider these four factors. Okay, stop the video now and think it over. All right, let's find out what the Supreme Court said. The Supreme Court said that in Harper and Row, there was no fair use. In this case, the court said that the purpose of the Nation magazine was to scoop Time and remove Time's value as first publisher. The court noted that the work was still unpublished, and thus fair use is accorded less latitude. The court noted that although the amount of the work that was used, the amount of the total book that was used was insubstantial, only 17% of the book, but it went to the heart of the book. It was the part where Ford pardoned Nixon. And finally, the court considered that the marketability of the book had been impaired because after the Harper and Row, after the Nation published the excerpt, Time broke its contract with Harper and Row and did not publish the excerpt or provide publicity for the release. As I say, this was a tough case. Most fair use cases are considerably easier to decide, but there's always some risk that the court won't see it your way. So I'd like to take a few minutes just to consider some common misunderstandings about fair use that many students have. Because YouTube doesn't allow me to upload a video that's longer than 15 minutes, I've had to break part 2 of this video into 2 pieces. So please proceed to the next section of part 2 on YouTube using the link that appears on Moodle. Thanks.